Welcome. Thank you for, I don't even remember at this point if it's our third or fourth installment of redistricting here in Ohio. Carrie Burns, Chief Strategy Officer with the Cleveland Metro Bar Association. Thank you all for being here this afternoon. We have a fantastic panel of local, and you'll see a new face today too, Mark Braden. So thank you so much for being here. Actually, two new faces, Kevin Cronin, who I'm going to introduce as our moderator this afternoon. This is for CLE, so those of you who are here for CLE credit, make sure you can hear and see us the entire time. There will be a poll question that pops up, not to trick anyone, but please make sure you select the correct answer because that is a requirement of the court. Finally, at the end of the program, there will be a survey. It will be emailed to you. Please make sure you fill that out in its entirety. So that is how we report to the court that you were here. So Kevin, thank you so much for being here. We are going to hear from our speakers first. Questions will be in the second half, so please have your questions ready. But Kevin, take it away.
Okay, thanks, Carrie. Thank you. Yeah, we're here on another round for talking about redistricting. We're going to add some twists here. We're going to be looking at not just Ohio, but we're going to be looking around the country and who's doing what and what happened. And we're pleased to have some wonderful guests here to further that discussion. My name is Kevin Cronin. I'm an attorney here in Cleveland at the beautiful Brown Hoist building. But we're going to go and get ahead with our speakers. Our first speaker will be Mark Braden, who's appearing from Washington, D.C. Mark is a lawyer with the Washington, D.C. office of BakerHostetler, and he's played a significant role in the redistricting process nationwide. His work concentrates on law and the political process, including elections and campaigns, voting, redistricting, and lobbying. He served for a decade as chief counsel for the Republican National Committee, as well as chief counsel to the Ohio Elections Commission and elections counsel to the Ohio Secretary of State. And he brings a broad nationwide perspective to our discussion today. Also today, we have Brian Glassman. Brian is a Cleveland State University School of Law professor emeritus. He is a graduate of Connecticut and Boston University Law School. He's been participating in many of these sessions, and we're pleased to have him back. He served as staff attorney to the Legal Aid Society of Cleveland and is active in the intersection of law and the arts. And third, by no means last, we have Katie Shanahan. Katie is an attorney and an activist with the group All On the Line, a grassroots organization and an active party to the Ohio Voter Rights Coalition. Katie received both her law degree and graduate degree from the Ohio State University, and it has been a keen policy analyst of the prior redistricting process. So we're going to start with you, Mark. You're the one who's had probably the most nationwide experience. Can you give us a sense of what's going on? And is Ohio unique, or are these sort of problems being faced by states all around the nation?
Well, Ohio's not unique. An outrageous amount of litigation over redistricting around the country. So I used to joke that you could only have more redistricting litigation if you admitted more states, but I was wrong about that. We've had a lot more litigation and haven't admitted any more states. But let me start with what people are generally interested in most of the time, actually without exception, which is the results. What's the political result of this redistricting cycle? And of course, we really don't know the answer to that until after this November election. But the best way to look at it, or what we can reach a degree of consensus on, is looking at the number of seats that Biden won, the number of seats that we would consider competitive, which basically will have a 5% range in Biden versus Trump votes, and those districts which Trump won in the new plan. And the change since the 2020 plan is basically there's one more seat, 188, in which that Biden won. There are 79 competitive seats, which is minus 11, and there are 10 more Trump seats. What that really reflects, to be candid, is the apportionment numbers. It's hard. You can go state by state, and each state has a unique story and who got what seat and didn't get that seat, and whether it's competitive or whether it moved. But the reality of the fact is that 10-seat movement for Trump simply reflects the apportionment. The new seats have moved to different locations. No longer is California growing relative to the other states. It's places like Texas and Florida, which have the substantial growth. And so almost all that change is reflective of the apportionment numbers. So, the big Democratic winner states in theory are California and Illinois. What a surprise. And the big Republican states are Texas and Florida. This, of course, is in theory, assuming that we can predict what's going to happen this November, which I don't claim any credit for. So let me talk real quickly about how this process has been different this cycle than in the past. And it goes to the census. The 2020 census had a lot of problems, the principal one being COVID-19. And so that drives the release of the census data, which is Public Law 94-171 data, drives the rest of the process. You have to have the census data to redraw the districts. The 94-171 data is the census data down at the so-called census block level, which is the level at which you construct representational districts. That would normally have been released to the states, starting with the states with the early election in the late winter of 2021 or early spring. They would start out with the states that had the early elections, and they would all be released by the end of March, maybe or so, under normal circumstances. None of the states got the election data. They were all released at once, and they weren't released to virtually the fall. This moved back the process around the country substantially. It didn't stop early litigation. A number of states, people decided they could file lawsuits before there were even census data out there. Those were obviously efforts to establish venue, classic, since we're all lawyers, classic forum shopping by the litigants. But so the process has been pushed back substantially because of that. In addition, the obvious problems of doing the census in the COVID environment, there were a number of other problems with the census. This gets pretty far in the weeds, but there's something called a differential privacy issue, where the Census Bureau decided that really a misguided decision, the Census Bureau, not that we're aren't in favor of privacy, but the notion that they could move around the numbers through an algorithm to attempt to hide individuals. It's resulted in the census data at the census block level not being dependable. At the tract level and up, it works fine, but at the block level, it's very clear that the data is not correct. That impacts adversely the process of dispute resolution or review. So those are significant problems with the census. And it really reflects the fact that the Census Bureau on the whole, the redistricting process is, although the only constitutional requirement of the census, is really secondary importance to them. They're really more interested in the other numbers. And this differential privacy has no impact on that, but it does have significant impact for those of us involved in the process. This is going to show up in later litigation when people start crunching the numbers and find out the numbers at the block level are wrong. There's some group quarter questions on how you assign people. The COVID really messed those up. And so the states did it a variety of different ways, in fact, internally in the states. And what that's basically is, perfect example, Columbus. Do you count the students at Ohio State in Columbus? Or do you count them at the residence? And that across the country, it was done different ways. Internally in states, it was done different ways. It clearly, undoubtedly resulted in some people being counted twice, showing up on their parents' forms back home, and then also showing up in forms sent by the university. And of course, the problem there was because of COVID, at the census day, a lot of people were not present in the dormitories, but were reported as present in the dormitories. So the census is a little messed up, but you have to dance with the one that brung you. So the census data is still and remains the gold standard for drawing districts. So we went into this cycle with really two areas of the law, out there were in the prior cycle that were significantly cloudy still. One was the notion of partisan gerrymandering in the federal courts. That's clearly now been decided by the Supreme Court and holding that the issue is non-justiciable. So except in some very limited circumstances where you're not going anywhere in federal court with a partisan gerrymandering claim. So what's left out there that's difficult to determine for the line drawers in the process going into this process was in fact racial issues. And the line drawers are confronted with what there are a variety of different ways to characterize this, but I would call it the twin peaks of liability. The Voting Rights Act, since Thornburg versus Jingles, has generally been interpreted by line drawers as, well, if you can draw the districts, you basically need to draw the districts. So if you can draw a line around a minority community, you needed to do that. And that's what the Voting Rights Act required. Now, there's a three-step provision in Jingles when it was enacted, but a lot of the states have traditionally decided to just go forward with the process based upon looking at that, saying, if we can do it, we do it, and we draw around and just step over the other steps involved in the Jingles analysis. That now has run into the other problem, which is in two cases, Bethune-Hill and Cooper, the Supreme Court has decided that, oh, well, maybe you really can't use race involved in the redistricting process. You certainly can't use it as a predominant factor in drawing. So the sort of line drawers going in this process were left with sort of the notion, do I have to draw these majority minority district under the Voting Rights Act, or am I prohibited from using race under the racial gerrymandering line of cases, Bethune-Hill and Cooper? And so that's has been a big problem for a lot of the states, and fundamentally is what underlies the Merrill case at the Supreme Court, where maybe the Supreme Court's going to address how to sort of balance the notion of, do I need to create these districts under the Voting Rights Act, or do I have a racial gerrymandering problem with using race in drawing the districts? So that's the problem that's out there. It might be addressed in Merrill, which is the congressional case from Alabama. It's not clear that it will be. There are some off ramps for the court on without dealing with that, but it's certainly possible that Merrill will address it. The most likely result in the Merrill case from Alabama, which is basically the creation of a plan by the district court in a preliminary injunction hearing in Alabama that created an additional black district that was significantly different than any district that had been created in the state. So that case may well address how to reconcile Thornburg versus Jingles versus Bethune-Hill and Cooper, but the most likely result is we're going to get a very split court, and it won't be clear as to where you go from here. So that's a 30,000-foot view of what's going on.
Thank you, Mark. That's been helpful to as a lead off on these sort of things. I mean, we are still, we went through this trauma here in Ohio with the Supreme Court and going back and forth. But right now, as we head into voting, voters will be casting ballots in congressional races and most of the state legislative districts that were twice ruled unconstitutional by the Ohio Supreme Court. So we're going to be having to face this challenge and work our way through it. Now, Professor Glassman, I understand you've got some material that you want to share with our viewers as well. Do you want to why don't you take the stage now?
I do, but I wanted to hand things off to Katie first.
Oh, okay. I'm sorry. We're going to go to Katie first. Okay. All right, I'm sorry, Katie Shanahan from
That's
the
okay.
Equal
Hi,
District
everyone.
Coalition. Thank you. I don't want to lose you.
No worries. And I just wanted to quickly clarify, I'm actually no longer with All on the Line. I'm an advisor to the Equal Districts Coalition, which is a coalition of progressive organizations working here on the ground in Ohio on redistricting. So doing a lot of the same work, just based here in Ohio rather than at a national org. So I wanted to give a little bit, most of the focus of today's conversation will be looking ahead to what's next with regard to redistricting, both here in Ohio and across the country. But first, wanted to do a quick look back at what's happened since the last time we met, because there is yet another update to our redistricting process. So since the last time we met, the state Supreme Court did again strike down a map as an unconstitutional partisan gerrymander, this time our congressional map, the one that we are currently voting under starting today, as today is the first day of early vote here in Ohio. So the court held that the map, which as a reminder gives 10 of our 15 congressional seats safely to Republicans, gives just 2 of our 15 seats safely to Democrats, and with 3 toss-ups that lean ever so slightly Democratic, although they really could go either way. I'm thinking especially of the Toledo and Cincinnati seats, although there's some stuff with the Toledo race that maybe has tilted that in a different direction. But the map essentially would give Republicans at least 67 or at most 87% of our congressional delegation. And the reason they struck that down as an unconstitutional partisan gerrymander is that Republicans have won just 54% of our vote in the last decade. And because the commission passed the congressional map along party lines with only Republican support, the Constitution prohibits any map that unduly favors one party over the other. Our current congressional map that's in effect for this election obviously unduly favors Republicans over Democrats. So they struck it down, starting what should have been a 60-day redraw period. Now, the reason that 60-day redraw period actually started tolling immediately after the decision was dropped, even though that map is not actually going to be overturned for this election, we're not going to have a new map until 2024, is that that's how the redraw process is set up in the constitutional provisions that are in place because of the 2018 reform measure. So that 60-day period starts as soon as the state Supreme Court issues their opinion, because that decision is not appealable in federal court. So there is one potential nuance there to that 60-day period where if the decision is appealable to a higher court, it gives obviously the 60-day period a jump back until that last day when an appeal could be filed. But the decision was based solely on state constitutional law, which obviously we all know means that it can't actually be appealed into federal court. You would have to bring up an entirely separate lawsuit in federal court with some federal claim attached to it. So that 60-day window came and went. It actually passed nearly a month ago at this point. We should have gotten a map at the very latest by September 17th. So the legislature got the first 30 days to do a crack at that redraw. They didn't do anything, didn't even try to do anything to redraw the map. Then it passed the commission with 30 days to try to redraw the map. They also didn't even convene or try to redraw the map. Very clear that they weren't going to. The only response that we got from any of the Republican leadership about this redraw process was a fairly disingenuous, in my opinion, memo from House Speaker Bob Cupp, who, as a reminder, is a former Supreme Court justice himself, saying that all of us activists were coming up with a mythical deadline of September 17th as the final deadline, that they actually have until October, because that's the final date by when they could appeal this decision into federal court. But I know that Speaker Cupp knows that that's not the case, because this case is not appealable to federal court. So that was not a mythical deadline. There really was a 60-day window by when they should have redrawn the map, and they did not. This is yet another example of what I think is an incredibly appalling display of brazenness in a disregard for court orders and the Constitution, and particularly of the people of Ohio, who overwhelmingly passed reform measures, not just to address congressional redistricting, but also state legislative redistricting. So where do we go from here? Of course, everyone is thinking about how we fix what went wrong in the reforms. And I will talk about that. But before we even get to whether or not we can put a reform up on the ballot, we have to get through this November and this US Supreme Court term. And the reason those two things are important is because they have a direct impact on our redistricting process. So I will use this as my reminder again that today is the first day of early vote. There are incredibly important races that directly impact our redistricting process on your ballot this year. They include folks who draw our maps both on the commission and in the legislature, and the state Supreme Court races. Those folks are going to be the ones who are judging future maps that are drawn, maps that we'll have to redraw before the 2024 election. So go out and vote either early in person or by mail or on election day. So why is this November's election important? Of course, there are races that will impact who actually draws our map, but I'm thinking specifically of the state Supreme Court races. Those races, of course, could tilt the balance of our court. And if I'm going to use a sports analogy, which is a little bit foreign to me, so I hope I get it all right. But if our goal ultimately is to have a strong democracy here in Ohio where everyone is on equal footing in their chance to elect representatives who actually represent and reflect their communities, where we have the ability to get fair maps, and where all of us have an equitable and full access to the power of our votes, then the state Supreme Court has really served as our goalie in that regard. Not just with regard to the redistricting process, of course, they have struck down actually 7 times in total all of our maps, 5 times on the state legislative front, 2 times on our congressional front, maps that were illegal because of the reforms that more than 70% of Ohio voters approved to rectify what happened in 2011. And what we got out of that is maps in place this year that are actually more gerrymandered than the ones that we had 10 years and 2 reforms ago. And that is a real travesty. And of course, there are lots of things that I would have loved to have been different in the reform language. I think the more independent the people you have drawing your maps, the better. So I think any politician, no matter the party, just can't be trusted to draw maps because there's just an inherent conflict of interest there. But we also, I don't think, had on our bingo cards just how the extent to which Republicans would go both on the commission and the legislature to ignore the rules that were in place. Our reforms failed because Republicans didn't follow the rules that were inherent in those reforms. There are actually good bits to those reforms that I think are essential to preserve when we go forward. So for example, we now have binding judicial precedent, or whatever that's worth these days, that our representational fairness requirement, we're the only state in the country that requires our state legislative seats to actually reflect how we vote, that 54-46% partisan breakdown over the last decade. It's really crucial that our court actually enforced that language. We don't only just have that protection in the Constitution. 5 times over, the state Supreme Court said these seats have to reflect those numbers, meaning Democrats should see 45 House seats and 15 Senate seats. We won't have anywhere near that this year. Maybe in 2 years we'll get that if we actually get fair maps for 2024. So those state Supreme Court races are really crucial because those decisions were made on a 4-3 breakdown. Chief Justice Maureen O'Connor was the swing vote in all of those decisions. It's not only the Chief Justice race that's important, it's those 2 other races that are important as well. They will have a direct impact on whether or not our state Supreme Court is even willing to uphold the demands of our Constitution and the promise of those reforms. The second piece that's incredibly important is a different case than the one that Mark mentioned up at the US Supreme Court, which is Moore versus Harper. At the heart of that is whether or not the US Supreme Court will endorse the independent state legislature theory, which until recently was a radical legal theory that suggests that only state legislatures have sole authority over election laws relative to federal elections, including redistricting. So that's congressional redistricting only, not state legislative redistricting. And the reason I think it's worth actually talking about this is that I think it's alarming in and of itself that that case was granted cert with ISL at the center of it, because for so long we have thought that the legislature alone is not who has authority to decide the time, manner, and place of federal elections, to decide access to the ballot, to decide who chooses electors, to decide how congressional districts are drawn. Courts have decided time and again that governors, of course, can veto those laws, but also what has normally been a central bedrock principle of federalism, usually a legal principle that conservatives love to tout, is that state courts are the final say on interpreting state constitutions and state law relative to federal elections. And here in Ohio, the state Supreme Court, as I said before, has been an essential goalie in our effort to get fair maps and to assure access to the ballot. Even there are decisions relevant to candidates even appearing on the ballot that were blocked by our Secretary of State. State Supreme Courts play a central role. If state legislatures are allowed unfettered access to have the final say over what goes, well, we'll see exactly what's happening in Ohio, which is where we have a state legislature and a commission that has completely ignored our state Supreme Court. Republican activist groups who forum shopped up into federal court to get a federal court to overturn a state Supreme Court decision about our state legislative maps, to get one that a decision that was based solely on state constitutional law overturned, essentially to let the state leg maps go forward this year. All of those things to me are major fire alarms that should be ringing, not just as everyday Ohioans, especially as lawyers, that we have 4 of our 5 Republican commissioners who are themselves barred attorneys, including a former state attorney general and a former state Supreme Court justice, so openly disregarding court orders is incredibly alarming. I keep coming back to that word because it really is. So of course, obviously we want to change how we go through this redistricting process, but first we have to understand whether we can even do that. And we won't know that until the end, how or if the US Supreme Court endorses the independent state legislature theory. If they do, we can't go to the ballot to fix congressional redistricting. Maybe we can go to the ballot to fix state legislative districting, but congressional redistricting will be relegated just to state legislatures. So that's something to look out for. And then of course, understanding the inherent impacts of the state Supreme Court races here in Ohio to understand the partisan balance of the courts. That's gonna have to be a necessary thing to think about when we're coming up with how best to safeguard our redistricting process moving forward. Thanks.
Thank you very much, Katie. That's great. I think it's very helpful for you to kind of hammer home on the central point that I think we're going to be returning to the idea of this North Carolina case time and time again. So thank you for touching on it. I think that it's an important part of the debate, and we'll see. But I think it's also important that you raised off of the first point, and that was that we started this whole redistricting process because we now have this new constitutional amendment and this new constitutional process. And this is the first effort for that. But I mean, keep in mind, 7 of 10 Ohio voters supported the idea of a process for redistricting. And now we're going to probably have to relook at that process again to come up and see what works. We've already gotten the criticism from the governor, but also criticism from the current Chief Justice, who will be resigning, and is called for a citizen commission. So we're going to have that sort of discussion. But the voters were very clear. 7 of 10 approved the constitutional amendment that said that it was unconstitutional to have partisan gerrymandering, and that they should keep it as a target, the partisan breakdown in the state. And on both counts, the Ohio courts repeatedly said that the maps failed to measure up. So we're in a kind of a new world right now, and we're going to have to kind of find our way through it. Many of the voters are going to be casting ballots in districts that are new to them, and we'll just have to kind of go through this process, this election cycle. Brian, I guess we're now turning to you, and I appreciate your contribution in the past. Are you prepared and you've got your slides rolled up?
Yes, let me make sure I can actually Hold on. Okay, hoping everybody can see my first screen. Is that right? Thank you, Katie. So my thanks to the Bar Association for inviting me to present again on these critically important topics at this critically important time. As you may know, we are waiting for oral argument to be scheduled in Moore versus Harper. More on that later. Here's a roadmap of what I'll be covering in my presentation. I'm going to be moving very quickly. Believe slides will be shared after this presentation, but I did want to cover a couple of foundational principles. For me, the North Star is participation. It's participation that makes our robust, our representative democracy robust. And where there are unnecessary voting restrictions, what the experts refer to as vote denial, where there's gerrymandering, referred to as vote dilution, those practices crush participation. The New York Times focused on participation more than about 2 years before the 2020 election, as you can see from the text that I've highlighted. And of course, there's Federalist number 51, which talks about, as you see, a dependence on the people, that the government derives its authority from the consent of the government. So let's disagree about who's the better candidate, who's got better ideas, not over how we cast ballots. Our election officials, as you see here, should use our election machinery to conduct fair elections, not to gain partisan advantage. I thought it noteworthy that Senate Minority Leader Mitch McConnell essentially said the same thing in late August when he cited candidate quality concerns with respect to Republican candidates for the United States Senate during this election run. Mark referenced the census. Here is a 30-second overview of reapportionment, redistricting, and gerrymandering. We do go from the census results to seats in the state legislature. To seats in the state legislature and also to seats in the United States House of Representatives. And yes, gerrymandering is fundamentally about two practices called packing and cracking, both of which enable the party in control to win as many seats as possible in that legislature. Always with gerrymandering basics, we need to be looking at these three questions. Wanted to give you a little history because it really matters here. Republicans realized in 2008, 9, 10 that the real power resides in the state legislatures when it comes to elections. And they targeted state legislative races. They realized that those races could be affected by relatively small amounts of cash infusions to those races. This strategy was extraordinarily successful. This is the point about how little money needed to be spent to win so many seats. And I just wanted to share with you this body of statistics because it shows the dramatic flip from 2008 to 2010 in the Ohio House. The other thing that's important to see here is that it's really been a one-way ratchet, that with Each successive election cycle, the margins have increased for Republicans in both the state house and state senate. Meanwhile, in a state that is approximately 54-46 statewide in terms of its voting patterns, Republican and Democratic, congressional seats, 75% of them in all election cycles over the last 10 years have been held by Republicans. So fast forward to 2019, when in Rucho, the US Supreme Court said this: federal courts cannot decide partisan gerrymandering claims. That was an invoking of what's called the political question doctrine. The court said there are no judicially manageable standards for federal courts to decide cases of partisan gerrymandering. A quick look at the two Supreme Court decisions. The first, with respect to the state legislative maps, underline, if you're taking notes, that word proportionality. It's in the constitutional provision, Article 11, and it's in the court decision from January 12, 2022. With respect to Ohio's congressional delegation, 2 days later, the Ohio Supreme Court issued its decision invalidating the proposed map because, as you see here, excessively and unwarrantedly favors the Republican Party and disfavors the Democratic Party. Significant that the Ohio Supreme Court specifically said that Article 19 does establish and provide judicially manageable standards for Ohio courts or the Ohio Supreme Court to apply in cases of this type. Fast forward to late May, when, as Katie was describing, the Ohio Supreme Court decided that the fifth version of the state legislative maps were unconstitutional. But in the meantime, the state legislative maps litigation wound up in, of all places, federal court. At the urging of Republican activists. So that was the case, notwithstanding what I just told you about the holding in Rucho, notwithstanding that the Ohio Supreme Court has exclusive and original jurisdiction under Article 19 of the Ohio Constitution. And also, just to reinforce the point that Katie made, notwithstanding that the Supreme Court is the final arbiter of what's constitutional under a state constitution. Republicans on the Redistricting Commission have ignored lawful Supreme Court orders on multiple occasions during this process. And so I do want to pose the question of the effect of those actions or inactions on the part of the General Assembly and the Redistricting Commission, the effect on our fundamental principles of separation of powers, respect for co-equal branches of government, our system of checks and balances, judicial review, judicial supremacy. And also, as a practical matter, Ohio winds up in a club that it should not want to be in. It's one of only 4 states, as you see, to use unconstitutional maps during this election cycle. And in a year when the race for control of the United States House of Representatives is so close, to be running unconstitutional maps in 4 states could well be the difference in the outcome. So why does it matter? Because it turns out our representative democracy really is a fragile thing. because you have the power to strengthen or weaken it. You as a voter, you as a participant in our system, in our representative democracy. And also because voting is not just a fundamental right, it is the fundamental right, since it protects all others. Don't take my word for it. The Supreme Court has been saying as much for over 135 years. As you see, it said it in this case from the 19th century, and it said it even more eloquently in Westbury versus Sanders, one of the malapportionment cases from the early to mid 1960s. So with that, I'm going to sign off in the hope that there will be enough time for me to say a few words about the independent state legislature doctrine during my round, during our round 2. Thanks.
Thanks, Brian. I appreciate your comments. And yeah, we will be getting into extensive question and answers and going on. I asked Katie if she'd come back and if we have a lot of questions piling on. If not, I'll take some first whack at some things.
No, we do have one question that came in early on, so I don't know if it's relevant anymore, but why doesn't the Ohio Supreme Court hold the Republican members of the Redistricting Commission in contempt? I feel like we've asked this question a lot of times, and I don't know if there's a good answer, but I will throw that to the group.
I think it's a good
Katie?
question. It bears repeating, especially given recent comments from the retiring Chief Justice herself, Maureen O'Connor, who lamented that there was nothing the court could do to rectify the situation. And in my opinion, I would respectfully push back on her to say there actually is. You could hold them in contempt for refusing to abide by court orders. And that, of course, would be a fairly large departure from how things normally work, because you'd have a state Supreme Court holding folks like the governor, secretary of state, and auditor and legislative leaders in contempt of court. But the reality is their actions themselves have been egregious in nature. There is no other group of defendants who could so openly and brazenly defy court orders and get away with it 7 times over. I asked some good friends of mine who are public defenders what would happen to their clients if they, in the same way, disregarded court orders in their cases. And their answers were swift. They'd likely be sent to jail. Their probation would be revoked. They'd be sent into drug remediation problems if that were relevant. It's a little, it's alarming to see how far Republicans are willing to go and how shy the Supreme Court has been. Of course, there's an immense amount of political pressure not to hold another branch of government in contempt of court. But as the professor just outlined, when the heart of the matter that you are hearing before you is whether or not Ohioans have the full power of your vote, I say go for broke and hold them in contempt.
I would add, and I would slightly disagree with Katie. I suggested in my presentation that we are really arguably in the middle of a slow-moving constitutional crisis where there is direct conflict between branches of our government, and the Supreme Court's decision not to hold these persons in contempt may have been based on a decision that to do so would have deepened that constitutional crisis. But I don't have a crystal ball. Those are just my 2 cents.
Thank you, Ron. Thank you. The Supreme Court's going to be terribly active on these on important issues. So I'm going to throw those questions out. I'm reminded that North Carolina is back in the Supreme Court docket. I remember an earlier effort where they were back in, and a reporter had asked one of the redistrictors, a legislator, saying, how can you justify 8-5? And he responded, well, they wouldn't let me justify 9-4. And unfortunately, that's the way things go, is that it's a partisan fight, and that you can't take the politicians out of the politics out of the politician. when they're involved in the redistricting. And that's maybe one of the central challenges that we're going to be facing when we try and redo a redistricting process. But there are two Supreme Court cases that are likely to be grabbing some attention. The first is Alabama. They've already heard cases, and that involves whether there would be one or two districts there. And then North Carolina, again, the discussion about who holds authority to be able to impose and oversee the rules of North Carolina and their process. Mark, do you want to start off the discussion on either of those cases?
Sure, I can talk about Merrill, which arises from Alabama. There a preliminary injunction was ordered in that case. The analysis appeared on its face to be a pretty straightforward Thornburg versus Jingles. It's a three-step test. It was a preliminary injunction. The Supreme Court stated under the theory on a variety of different theories, but basically it appears to be driven by a timing issue. The argument is whether in Merrill, it's fundamentally the conflict between the Thornburg versus Jingles lines of cases and the racial gerrymandering line of cases. And that really came up out of Virginia and North Carolina in a case from North Carolina, the Cooper case. And what the conflict is, to draw districts under Section 2, you certainly have to use primarily or predominantly, to use the language floating around, race. You have to consider race. They don't happen by accident. To draw the district in Alabama, you had to predominantly use race. You had to, there's various statistical analysis, but out of a million plans drawn by a computer, none of them come up with 2 black districts. They only come up with 1 black district. So that appears to be in conflict with the language in Bethune-Hill, both the Bethune-Hill cases and Cooper, where race can't be used predominantly in drawing districts. So the conflict is there. How you're going to deal with the two issues isn't clear. There are 2 members of the court who think that the Voting Rights Act doesn't apply to the redistricting process, which I think is pretty clearly wrong. It was probably correct at the time it was enacted, but the Congress has reenacted it a number of times with a broader interpretation. So we know for sure that 2 people are in favor of overruling the Alabama case. Where the rest of the court comes down on this, I will tell you, is not clear. It would help if we would get some guidance, because the line drawers in this process now simply don't know. Some of the states decided to draw race blind for fear that they were going to conflict with Cooper and Bethune-Hill. But that obviously raises the questions under Thornburg versus Jingles. So Merrill is the important case. Unfortunately, I'm not optimistic that we're going to get a majority opinion that's going to clearly get us guidance as to how for the line drawers to move forward in balancing the racial issue. We're probably going to get a seriously divided court with 3 or maybe even more opinions.
I would like to jump in and just say the Voting Rights Act was passed to address racial discrimination in voting. When 25 or 27% of Alabama's population is African American, and only 1 congressional seat is a seat that allows that population to elect the representative of their choice, that's strong evidence that there is racial discrimination in voting in Alabama. Again, the test is discriminatory effect, not discriminatory intent. And it would be easy enough to draw Alabama's congressional districts to include 2 seats where the African-American population in that state is free to elect the candidate of its choice pursuant to the commands of the Voting Rights Act.
And the court did approve a map that had 2 seats. That was one of the questions, and that was overturned then on appeal. But there was at least one map that did address that question.
Sure. Well, first of all, it's not easy enough. That's abundantly clear. If you do the various, a lot of people are in favor. I'm sure there's some people on this phone call are in favor of let the computers do it. Well, if you let the computers do it, what you do is you don't come up with 2 seats in Alabama. You come up with 1 seat using traditional redistricting criteria. We have the same problems. We have this fundamental problem that a lot of this discussion has missed, which is redistricting is about both politics and geography. The problems with going from a gross overall number and say, oh, wow, if we get X percentage, we should get X percentage of seat because we're X percentage of the vote or X percentage of the population, belies the fact that that's not how it works because we don't have a homogeneous society. The reason why there's a huge, no question that there's significant advantage to Republicans in geography. And folks familiar with politics in Ohio, that's no surprise. Democratic vote in Ohio is significantly concentrated in a few locations, much more concentrated across the country in a few locations than the Republican vote. If you have a geographically based system, there's going to be a disconnect between percentages and percentages of the vote in the elections and the percentages of seats that you win. So that now, is there a point at which that becomes too large? Well, there's a lot of dispute over that, but there really isn't any fundamental dispute unless we're going to change our system. We could have a system that many European countries have, which is a list system where percentage of the overall vote in a state gives you the percentage of seats that you get from a list. We could do it that way. I mean, we could change our system and do it that way. We don't do it that way because but this geographic component has a significant impact across the country. I wasn't involved in Ohio, so it's hard for me to comment on Ohio. But when somebody says, well, you should only get 54% of the seats because that's the vote you got statewide, that presents problems under geographically creating districts. And it also presents problems on the racial side. So the sort of notion that you can go from gross numbers, and that's the number of seats you should get, is simply unhappiness with a geographically based system.
I
Katie,
would
are
like
you
to
trying
just
to jump in? Okay.
Yeah, I'd like to push back on that because in Ohio, that was the exact argument that Republicans gave about why they had to draw the maps as gerrymandered as they did, because our political geography necessitates a map that gives them undeserved supermajorities in both legislative chambers and in our congressional delegation. The reality is political geography is not an excuse to gerrymander. And that is something that the Ohio Supreme Court itself endorsed in all 7 of their opinions, because all of the Republicans said, oh, there's no way for us to abide by all of these rules and hit the numbers because of political geography. And they were proven wrong by the maps that were proposed by Democrats, maps that were proposed by the Ohio Citizens Redistricting Commission, which was a grassroots effort that folks on the Equal Districts Coalition helped provide. They were proven wrong by expert maps that were submitted to the court as part of litigation, all of which offered maps that hit those numbers and didn't unnecessarily crack apart major metropolitan areas to draw them into more rural and Republican districts, which is what the Republican mappers did. Now, I can't speak to Alabama because I don't know the geography of Alabama, but what I can say is this: political geography, of course, does present certain challenges in Ohio. It is not an excuse to gerrymander. Of course, you are going to have districts in and around, especially the major areas that are heavily Democratic, where you are wasting a lot of Democratic votes. If you're looking at Cleveland, for example, Cleveland is not only where there's a huge concentration of Democratic voters, but also the biggest concentration of Black voters. You, of course, are going to get districts that are overwhelmingly Democratic, and in some cases, overwhelmingly Black, because that's just who lives there. But to suggest that we can't even get close to hitting the constitutional requirements for representational fairness because of political geography is just not correct.
Okay. Well, I'm sure we could go back and forth again and again, but let's turn to the other issue that will be coming before the Supreme Court. That's Moore v. Harper out of North Carolina. They have not yet set dates for hearing that case, but everybody's looking at that one as going to be potential for a blockbuster. What they're going to be looking at there is they're going to look at oversight and review. Who has the authority to review the maps prepared by the legislature? Under this independent state legislature theory, does the legislature stand immune from judicial oversight, both by the state judiciary and by federal oversight? And so we'll throw that issue out now to our panel of experts. Who wants to weigh in on North Carolina?
I'd be happy to go first.
Why don't you go first?
Okay, thanks. Again, let me go to this slide. Just give it a moment to click in. Is the independent state legislature doctrine actually a doctrine? Well, not if it hasn't been articulated and followed consistently for a good length of time. ISLD proponents assert, as you heard Kevin just say, that a state legislature has unchecked authority to craft voting laws, not constrained by a state court's examination of whether those laws comport with the state constitution. And another consequence, carried to its logical extreme, would be the elimination of independent redistricting commissions by ballot initiative. Such redistricting commissions could only occur if the state legislature handed off its authority in voting matters to such a commission. So this, we could trace it back to a Supreme Court decision in 1932 called Holm versus Smiley. But then you get some reference, that is to say, in which the Supreme Court said there's no such thing as the independent state legislature doctrine. You do get Chief Justice Rehnquist's concurrence in Bush v. Gore. He makes the argument about those words, the legislature, appearing in this instance in the electors clause, as we were having a dispute over the outcome of that presidential election. But then you got a very clear determination from the Supreme Court in Arizona State Legislature, Justice Ginsburg writing for the majority, reminding everyone that political power flows from the people. And as you see here, voters should choose their representatives, not the other way around. I am very concerned about an argument that suggests that this one legislative function somehow is not subject to the standard checks and balances that are built into our system of government. I'm going to leave it there because I'm sure that some of my other presenters would like to speak.
Thanks, Brian. I appreciate that. You know, there are a number of odd little twists to this North Carolina thing that really need to play out. And for instance, you know, the North Carolina state legislature specifically gave the court the authority to impose a temporary redistricting plan, which is what is at stake in coming before the Supreme Court. Also, they tend to ignore the second half of the constitutional provision. Yes, there is broad authority for the idea that you know, the states are the ones who regulate time, place, and manner. But the second clause of the article also talks that that the Congress may at times change that by law. So again, we're right back to this sort of oversight. Oversight and judicial review have been a part of America long before the Constitution, even before the Confederacy of America had provisions for judicial oversight. So I think we're going to be right back to some very standard sort of principles as the court works through that sort of issue. Mark, you're shaking your head and you sound like you want to dive
I think,
in.
more doesn't involve any notion of the federal constitution not being able to regulate it, nor any notion of federal courts not being able to regulate, and no notion of the states courts not being able to use federal constitutional or legal or statutory provisions to impact it. So it is not the blockbuster. I don't view it as the blockbuster, or people argue that it is. First of all, I absolutely reject the notion that that it would overrule the Arizona Commission or have any impact on commissions like in Michigan. The Arizona Commission is the real holding of that opinion, in my view, is that what was happening there is that the legislative process, quote unquote, was in fact the initiative process. So that's one can dispute whether that is a good way to interpret it or not, but that's the I don't see, and I think it's pretty clear, they don't have the votes in the Supreme Court to overrule Arizona. That's not going to happen in this opinion. That two reasons it isn't going to happen. Let's look at the facts of North Carolina. North Carolina, the Supreme Court of North Carolina, in a totally unprecedented, decided to overrule very recent precedent in the state, really only a couple of years old, that this was a political question, as the way it's been held historically in North Carolina, that the line drawing process was assigned to the legislature and they should do it. And so they crafted their own plan. So the so-called origin of this doctrine is in the language of the US Constitution. It assigns this to the legislature. That's not an accidental assignment. The original language, the original draft of the Constitution did not in fact assign it. It assigned it to the state. Additional language was placed in the Constitution to make that assignment to the legislature. If you go through the Constitution, there are a number of assignments of powers bought from the federal government to the states. Sometimes there's assignments of power to the executive of the state, and then sometimes there's assignment of powers to the legislature. Words have meanings. So what's going to happen in this case certainly is not clear, but I'm relatively comfortable that is what we're looking at here is the real driver of this is this sort of unprecedented action at the state court by the state court in North Carolina, and I would say in Pennsylvania too, to move from a judicial function to a legislative function and simply take over a legislative activity. And one that was assigned, again, not by accident. You can go through the commentaries of Story and Daniel Webster and interpreting these provisions. And I'm a little bit amazed at how people are so exercised over it. The only real precedent of these cases, if you look very carefully, really involved the Civil War and the fact that some people argued that Union soldiers who had been granted by the state legislature the right to vote absentee shouldn't be able to vote because the state constitution didn't permit them to vote absentee. So there is a little bit of litigation on this issue, which goes back and forth both ways. This is not some bizarre notion that dropped from the sky.
Yeah. Well, we're going to have to start moving towards a closure here. Carrie, we'll have to start. Well,
we're
we'll
over
set the
time.
table for another sort of discussion, and we're going to have to be able to come back at another day. We never even got into the Supreme Court Justice O'Connor, who signed on to an amicus brief to the Supreme Court, talking about the important roles the state courts are going to have in evaluating that sort of decision, and that urging them to kind of tread carefully. But we'll have to save that for another day. I want to thank all our panelists for appearing here today. They've again contributed greatly, and I appreciate your time. And we'll just have to come back another day on some of these sort of issues. I'll send it back to Carrie.
Thanks, Kevin. Thank you, Mark, Brian, and Katie.
Thank you.
All for being here. Stay tuned. I'm sure we're going to have, round 30 at some point. I hope not, but it's looking that way. Everyone have a great afternoon. Take care.
Thank you.
Much.